Hello everyone, welcome back to our channel where we simplify complex world of international trade finance. In today's video, we are diving into an essential topic for professionals in trade finance and guarantees. Issuing a demand guarantee or standby letter of credit under URDG 758. Let's get started. First, let's understand what happens when a demand guarantee is issued. According to the Uniform Rules for Demand Guarantees or URDG 758, issuing a demand guarantee triggers three critical consequences. First one, the guarantor or counter guarantor becomes irrevocably committed from the time of issue. Second, unless otherwise specified, the beneficiary can present a demand immediately upon issuance. Third, the applicant or instructing party is usually responsible for the guarantor's charges from the date of issue. This brings us to an important question. When exactly is a demand guarantee considered issued? There are several possible benchmarks, including the date on the document, the time it is sent, when it leaves the guarantor's control, when it is received by the beneficiary, or when it is accepted by the beneficiary. In practice, these dates might differ. For example, imagine a hard copy of guarantee is signed and dated on Tuesday but held by guarantor until Wednesday morning when it is handed to a courier. The courier delivers it to a beneficiary on Thursday. Is the guarantee issued on Tuesday or Wednesday or Thursday? According to URDG 758 subarticle 4A, a guarantee is issued when it leaves the control of the guarantor. But what does leaving control means? The International Standard Demand Guarantee Practice or ISTGP provides further guidance. For example, handling a document to the courier does not meet the requirement for issuance. In our example, the guarantee would be considered issued on Thursday, the day it is delivered to the beneficiary. This position comes from ICC's decision that until actual delivery, the guarantor might retain the right to instruct the courier not to deliver the document. However, this interpretation is not absolute. Specific facts or courier terms of service could influence the court's decision differently in case of a dispute. We will discuss this in more detail. Issuing a demand guarantee or standby letter of credit. The issuing of a demand guarantee triggers three consequences as we earlier discussed. The guarantor or counter guarantor is irrevocably committed from the time of issue. Second, unless the deferred time is expressly indicated, the beneficiary can present a demand from the time of issue. And the applicant or instructing party will normally be responsible for the guarantor's charge from the date of issue. It is therefore important to determine with certainty exactly when a demand guarantee is issued. There are several potential tests to determine the time of issue. These include the date on the document, the time when guarantee is sent, the time when it leaves the control of the guarantor, the time when it receives the beneficiary, the time when it is accepted by the beneficiary. In many cases, the date on the document or the date on which it is sent and the date on which it leaves the control of the guarantor will be the same day. However, these could also potentially be different days. It is possible that a guarantee may be signed and dated on Tuesday but held overnight by the guarantor until it is handed to a courier on Wednesday morning, with delivery taking place on Thursday. Is the guarantee issued on Tuesday, Wednesday, or Thursday? As we earlier discussed, URDG 758 subarticle 4A provides that a demand guarantee is issued when it leaves the control of the guarantor. But that still leaves some uncertainty to the concept of control. Further guidelines on the interpretation of subarticle 4A is addressed in ISDGP D67 to 71. Also, ISDGP D70 treats the courier as the agent of the guarantor and state that the transmission of the guarantee to an agent such as a courier does not meet the requirement for issue. In the example, if the guarantor hands the guarantee to a courier on Wednesday for delivery to the beneficiary, the guarantee will be issued on the day of actual delivery, that is on Thursday. This concept of control is not an easy area to address, and the guidance provided by ICC in ISDGP does not deal with every aspect of this issue. In practice, it is generally accepted that an advising party would be treated as an agent of the guarantor for the purpose of determining whether a guarantee has been issued, although this is not directly addressed in ISDGP. There is no obligation on the beneficiary to accept a demand guarantee, but the guarantor is bound by the terms of the guarantee from the date of issue. URDG 758 subarticle 4B confirms that the guarantee is irrevocable on issue even if the guarantee does not state it is. Subarticle 4C states that the beneficiary may present a demand from the time of issue of the guarantee or such a later time or event as the guarantee provides. Now, what happens when a demand guarantee is not subject to any specific rules? In this case, you will need to carefully review the guarantee itself. If it includes an express terms defining when it is issued or takes effect, you follow that. But what if it is silent on this matter? Here is where things get tricky. You might have to investigate the governing law of the guarantee. However, this does not always provide a clear answer, as laws and interpretations vary. So, always aim for explicit terms in the guarantee to avoid ambiguity. Now, let's talk about standby letters of credit under ISP98. The ISP98 Rule 2.03 clearly defines issuance as a standby is considered issued when it leaves the issuer's control. However, if the instrument explicitly states it is not issued or enforceable, it will not be binding until those conditions are met. Interestingly, terms like not available, not operative, or not effective does not negate the standby's irrevocable nature once it has left issuer's control. This means even if specific conditions must be met for standby to become operational, it remains binding and enforceable. This flexibility allows banks to issue draft instruments, which demonstrating the terms they are willing to commit to the future without creating immediate enforceable obligations. Let's discuss them in more detail. ISP98 Rule 2.03 provides a standby is issued when it leaves the issuer's control unless it clearly specifies that it is not then issued or enforceable. Statement that a standby is not available or not operative or not effective does not affect its irrevocable and binding nature at the time it leaves the issuer's control. The concept that the standby is issued when it leaves the issuer's control is similar to the test used under URDG 758 Article 4. Further, it is made clear that terms in the instrument stating that it is not operative or not effective until a particular document is presented do not affect the irrevocable nature of the standby. However, Rule 2.03 does acknowledge that the status of the standby as an issued undertaking may be overridden by a clear statement that the standby has not yet been issued. This allows for a production of a draft instrument in which the issuing bank is demonstrating the terms of the standby letter of credit that it is prepared to issue at a future date or upon future conditions, but it is not issuing right now. Issue of a counter guarantee under URDG 758. Now, How about counter guarantees under URDG 758? These are subject to the same rules as demand guarantees. According to URDG 758 Article 4, a counter guarantee is considered issued when it leaves the counter guarantor's control. But what happens if the prospective guarantor rejects the counter guarantee? In this case, the counter guarantor is released from the obligation. This clarity ensures a smooth process in the chain of guarantees. The provision of URDG 758 Article 4 applied to the counter guarantee in exactly the same way as it applied to demand guarantees, since URDG 758 Subarticle 3A provides, except where the context or otherwise required, that the term guarantee includes counter guarantee as well. The counter guarantor is irrevocably bound from the moment the counter guarantee leaves its control. However, if the prospective guarantor rejects the counter guarantee, the counter guarantor is released from its obligation under the rejected counter guarantee. In today's digital world, guarantees are often issued electronically, such as through SWIFT MT760 messages. Under URDG 758 Article 4, the same issuance rules apply. For electronic guarantees, the issue date is typically recorded automatically at the time of transmission. However, if a bank uses its own e-commerce platform, you will need to understand how the platform dating mechanism works to determine the exact point when the guarantee leaves the issuer's control. In another word, the same test under URDG 758 Article 4 also applies to the date of issue of the demand guarantee in electronic form. Let's discuss advance payment guarantees. These guarantees protect buyers by ensuring repayment of prepaid amounts if the seller fails to deliver as agreed. Under URDG 758 Subarticle 4C, unless explicitly deferred, the beneficiary can make a demand from the time the guarantee is issued. But here is where it gets interesting. To resolve potential conflicts between buyers and sellers, advance payment guarantees often include a clause stating no demand can be made until a prepayment has been completed. This ensures fairness for both parties. The buyer knows it is safe to prepay because the guarantee is irrevocable once issued. Also, the seller is assured that no demand will be made until payment is received. So, how does the guarantor determine that the payment has been made? Remember the principle. Demand guarantees are documentary. This means the guarantor relies on the presented documents to verify complaints, as non-documentary conditions aren't typically allowed. This keeps the process clear and efficient. In other words, we have seen that one of the consequences of the issuing of the demand guarantee is that unless a default time is clearly indicated, the beneficiary can present a demand from the time of issue or such later time or event as guarantee provides. This principle is set out in URDG 758 Subarticle 4C. Here, the words or such later time or event as the guarantee provides are a specific reference to the operation of advance payment guarantees. An advance payment guarantee covers the risk that seller or manufacturer of goods does not repay all or part of the price which has been prepaid by the buyer in the event of failure to deliver goods or services in accordance with the terms of the underlying contract. The buyer, that means a beneficiary, will not want to make the prepayment to the seller until the advance payment guarantee has been issued. However, the seller, as an applicant, does not want the buyer to have the right to make a demand under the guarantee until the buyer has made an advance payment. This tension between the interest of buyer and seller can be resolved by including a provision in the advance payment guarantee to the effect that no demand can be made under guarantee until the prepayment has been made. The beneficiary knows that once the advance payment guarantee has been issued, it is irrevocable and it is therefore safe to make a payment. Conversely, the applicant knows that the beneficiary cannot make a demand until an advance payment has been made. This in turn leads to a question how the guarantor can determine that the advance payment has been made. So the guarantor can then make payment under the guarantee against presentation of demand. You will remember the basic principle set out in URDG 758 Article 7 that the demand guarantee is documentary in nature and non-documentary conditions are not be included in a demand guarantee. Now, advance payment guarantees without rules. Imagine you are a buyer preparing to make an advance payment, but the guarantee states that it won't take effect until the payment is made. Sounds risky, right? This type of wording can create confusion. It might imply that the guarantee is revocable until the payment is completed, which leaving the buyer unprotected. To address this, best practice dictates the advance payment guarantee should be irrevocable and binding from the moment it is issued. Second, clear in stating that no demand can be made until the advance payment has been received or document is presented as evidence of payment. This approach ensures fairness for both parties. The buyer knows it is safe to make the payment while the seller or guarantor can rely on documentary evidence to proceed. This structure aligns with URDG 758, particularly Article 4 and 7, where these articles emphasize guarantee is irrevocable upon issuance and any conditions requiring fulfillment must be tied to a specific document for compliance. The better approach is to make it clear that the guarantee is irrevocable and binding to the guarantor from the moment it is issued. The buyer will therefore know that it is safe to make a payment, and the guarantee should, however, state that no demand can be made until the advance payment has been received by the guarantor or bank. Now let's look at the advance payment guarantee works under ISP98. Rule 4.11 of ISP98 aligns closely with URDG 758 when it comes to non-documentary conditions. Here is what Rules 4.11 says. Non-documentary conditions are disregarded. For example, if a guarantee states that payment is contingent on a vague condition without requiring supporting documents, such a condition is treated as if it does not exist. Second, conditions must be verifiable through records or documents. Determinations such as when payment is made or when a document are delivered must be based on the issuer's own record or specific indices. This ensures that the guarantee remains clear, enforceable, and compliant with best practices. So, whether you are working with guarantee governed by ISP98 or not subject to any specific rules, here is how to structure it effectively. Clarity in the wording. Specify that the guarantee is irrevocable upon issuance. Also, clearly state that no demand can be made until the advance payment has been completed. Second, documentary evidence. Require the beneficiary to present a document, like a receipt or confirmation of payment to make a demand. Third, alignment with best practices. Follow the principle of ISP98 Rule 4.11 or URDG 758 Article 4 and 7, even if the guarantee is not explicitly governed by these rules. This approach reduces ambiguity, protects both parties, and ensures the guarantee serves its purpose effectively. So, here is a quick recap of today's section. An advance payment guarantee must be irrevocable from the moment it is issued, even if the advance payment has not been made yet. Second, documentary evidence is crucial for fulfilling conditions and ensuring compliance. Third, align with recognized rules like ISP98 or URDG 758 to avoid confusion and legal risk. By structuring guarantees in this way, both buyer and seller can proceed with confidence, knowing their interests are safeguarded. That's it for today's video. If you found this helpful, give it a thumbs up and don't forget to subscribe for more trade finance insight. Have questions about advance payment guarantee or any other topics? Drop them in the comment below and we will cover them in future videos. Thanks for watching and see you next time.